All right, let's talk about personal guarantees. They're the real wealth killer. Nothing will kill your wealth faster than a personal guarantee. Last month, a real estate investor in Miami lost his family home. He lost his savings. He even lost his daughter's college fund. The worst part, he didn't lose them in the deal itself. He lost them because of 4 words he signed without thinking. Those 4 words were personal guaranteed by the undersigned. In this video, I will explain personal guarantees, the silent wealth killer in Florida deals. By the end of this video, you will learn why personal guarantees are far more dangerous than most business owners realize. You'll understand the specific risks in Florida, and you'll discover how to protect your personal assets before it's too late. I'm Santiago Cueto, board certified international business law expert and best-selling author based right here in Miami, Florida. I've spent nearly 3 decades helping Florida entrepreneurs protect their wealth from legal landmines just like this one. Here's what happens in almost every Florida business deal. You're excited, you're ready to grow, maybe you're signing a commercial lease, maybe you're getting equipment financing, perhaps you're partnering on a development project. The contract arrives. It's 30 pages long. You flip to the signature page, right there, in small print, you see it. The personal guarantee clause. Your broker says it's standard. Your partner says everyone signs them. You think your LLC will protect you, so you sign. That signature just erased the corporate veil you've spent thousands of dollars creating. Your business debt became your personal debt. Your company's liability became your family's liability. All because of this one killer clause. Most people don't realize what they've done until it's too late. The business struggles, revenue drops, and creditors start calling. Then comes the shock. They're not just coming after your business, they're coming after everything you own. Your home, your car, your retirement account, and even your spouse's assets. The LLC was supposed to protect you. It means nothing now. You guaranteed the debt personally. Let me tell you about Carlos. Carlos owned a successful restaurant chain in South Florida. He wanted to expand. He signed a lease for a new location. The landlord required a personal guarantee. You see, Carlos thought it was no big deal. Business was good, then the pandemic hit. His restaurants closed. Revenue disappeared overnight. He couldn't pay rent. The landlord sued. But here's the critical part. The landlord didn't just sue the business. The landlord sued Carlos personally. Carlos lost his primary residence. He lost his vacation property in the Keys, and he lost his investments he'd been building for 20 years, all because of one personal guarantee on one lease. This story repeats itself every single day in Florida. Personal guarantees are everywhere. Commercial leases demand them. Banks require them. Suppliers insist on them. Landlords won't negotiate without them. The problem isn't just that you're liable. The problem is how far that liability extends. In Florida, creditors are aggressive. They can pursue your assets relentlessly. Wage garnishment, bank account levies, liens on property. It doesn't stop until they're paid in full. Now, if this information is helping you protect wealth, do me a favor and hit that like button right now and subscribe to this channel. I share legal strategies every single week that Florida business owners need to know. These could save you hundreds of thousands of dollars. Now, let me explain why Florida makes this even worse. Florida is not even a community property state. That sounds good at first, but it creates unique problems with personal guarantees. If you're married, your spouse doesn't automatically co-own your assets. That seems protective, but creditors know this. They structure guarantees to pierce through marital protections. They'll go after jointly titled property. They'll freeze joint bank accounts. They'll even target assets your spouse thought was safe. Florida does have homestead protection. Your primary residence does have strong credit protection under Florida law. But here's what they don't tell you. That protection has exceptions. Personal guarantees can create those exceptions. If you pledge your house as additional collateral, homestead protection disappears. I've seen this destroy families. A business owner thinks their home is safe. They sign a personal guarantee. The guarantee includes a confession of judgment clause. That clause waives their homestead rights. They lose everything. Florida also allows deficiency judgments. Let's say your business owns property securing a loan. The business defaults. The lender forecloses. The property sells for less than the loan amount. That difference, that's the deficiency. With a personal guarantee, you owe that deficiency personally. This happens constantly in commercial real estate. Property values drop, sales don't cover the debt, the personal guarantor gets stuck with hundreds of thousands of dollars in deficiencies. Their personal assets get liquidated to cover it. All right, so what do you do? How do you protect yourself? Well, first, you want to negotiate. Many landlords and lenders will accept limited guarantees. They'll cap your liability at a specific amount, and they'll limit the guarantee to a specific time period. They'll accept guarantees from other entities instead of you personally. But you have to ask. You have to negotiate before you sign. After you sign, you have zero leverage. And second, never, ever overpromise. If the lease is for 5 years, negotiate a guarantee that expires after 3 years. If the loan is for $2 million, negotiate a cap of $500,000. Something is better than unlimited personal liability. And third, understand what you're signing. Look for waivers of homestead protection. Look for joint and several liability language. Each of these makes your situation so much worse. And fourth, consider alternative structures. Sometimes additional corporate guarantors satisfy the creditor. Sometimes a letter of credit replaces a personal guarantee entirely. And fifth, protect your assets. This is critical. Florida has strong asset protection tools, but you must use them before creditors come calling. After a lawsuit starts, it's too late. Transfers look fraudulent. Protection vanishes. And here's what you need to remember. Personal guarantees are not just formalities. They're not standard clauses you can ignore. They're legally binding promises that put everything you own at risk. Every time you see those words, personal guarantee, stop. Just stop. Read the terms. Understand the exposure. Negotiate limits. Consider alternatives. Protect yourself before signing. Your business might fail, markets change, and circumstances shift, but your personal wealth doesn't have to disappear with it. That's what limited liability was supposed to protect. Don't sign it away without understanding what you're doing. If you found this video helpful, hit that like button and subscribe to my channel for more legal strategies that protect Florida business owners, and share this with someone who needs to hear it. These principles could save them from financial disaster. I'm Santiago Cueto, your Florida business attorney. Be sure to watch more of my videos right here.